Good morning and welcome to a special edition of KPRC 2 Plus Now. I'm Zach Laswell. You know, it was 1 month ago today I stood in this newsroom and introduced you to The Bench, our exclusive coverage, a multi-platform experience that brings you inside the murder trial of AJ Armstrong. 1 month later, today, the players are cast. We have 6 women, 10 men seated as jurors. We have AJ Armstrong, of course. This was taken back in 2016. This photo in 2019 during his second trial. Today, we're here in 2023. This child is a young man, now married with a young son of his own. At the center of this case, his parents, mom and dad, high school sweethearts. Dad, a former NFL player. AJ is accused of murdering his parents inside their own home when they were sleeping. So this morning we're asking several questions, including who will be called to testify and what, if anything, will prosecutors do differently to ensure they do not end with another hung jury. Ladies and gentlemen, this is The Bench.
Roll the open.
Good morning. We are live as live can be downtown. Courthouse right behind us where a lot of activity is going to be happening. What time does court start today, Rilwan?
Today, 8:30, so in 30 minutes or so.
So you're jumping out of here before this show's even over.
Exactly.
Okay, let's do the intros real quickly. I'm a reporter, Joel Eisenbaum. Letitia Quinones, criminal defense attorney, has been tied to some of the biggest cases in town. And Rilwan Balogun, just like me, a reporter who's been really inside the courtroom and has seen everything that's gone on. Has it been a month already? Is that how long?
Yeah.
But we have a jury.
Entire month, more than 200 people walking into the Criminal Justice Center here for the whole voir dire process. A member of our bench team has been inside that courtroom the entire time trying to learn about who these 16 people are that we now know have made the official jury selection. It's been a wild month and things are just now really getting started.
So how big? So we went from 200 to like what, 48, and now how many?
16.
16, so that's 12 and 4 alternates.
Yeah.
That's correct.
More alternates than usual.
Yes. Normally you have about 2 alternates, but in bigger cases you're going to get 4.
Kelly Johnson's kind of the judge, is kind of like belt and suspenders. I want to make sure we've got everything we need, everybody we need. And we don't really even have an exact understanding of who the 12 regular jurors are and who the alternates are.
Well, I think you can kind of really deduct who those 12 are just based on how they're seated. You have to remember that the jurors are deselected, right? They're moved because of any biases or reasons for cause. And then the first 12 that are left is going to be what we call your pettit jury, meaning the jurors who will actually deliberate on the case.
Isn't it just dumb luck what your number happens to be, though?
Yeah, but remember, if you remember, there was a shuffle, I believe, right? When it first happened.
Right at the beginning, yeah.
So that is the whole purpose of it. You want the people that you want on your jury, you want those people in the front, because those are the people that will end up on the jury, the people who are closest to the front. So if you look at the jurors as they were seated, and we look at the numbers, juror number 149, number 155, number 172, and number 179, I bet you those are our alternates because they are at the back.
Got it.
So because they're at the back, that pretty much tells you those are the alternates.
Do we have an idea of the makeup of the jury then, right?
Yeah.
Men versus women, what do we have?
Yeah, as Zach said there, we have 10 men, 6 women. I believe that I'm being correct there.
Yeah.
10 men, 6 women. From what we have seen, this is an extremely diverse group of people.
Yes.
Extremely diverse. So once they were all seated, the reporters in the room looked at each other like, wow, this really I would say, makes up the makeup of Harris County.
Yeah.
Kind of doing a deeper dive in it, the ages really range from the youngest, I believe, is in the mid-20s, to the oldest that has self-identified. She's a 64-year-old grandmother which is what I was listening for, because during our first episode of The Bench, you mentioned the ideal juror.
Yeah.
And you were looking for a grandmother.
Absolutely.
And so during the whole voir dire process, I'm listening for grandmothers, and we have at least 2 grandmothers that I'm for sure of that's part of this jury.
That's what you want, though, right? Everyone from all sorts of different walks of life. Here comes the big poster with all the players.
Yeah.
Yeah.
That's nice. That fits right in there, Andrea. Gonna alligator clip that. I'll hold the bottom. So, okay, so we've got everyone. So is that, they're gonna be in court today? They don't show up in court today? Who's there for the motions?
No, the jurors are not there for the motions. Motions are heard outside the presence of the jury. Now, before we get off the jury, let's talk about who makes up the pettit jury, the ones who deliberate. I believe we're going to have 5 Caucasians, 2 blacks, 1 Asian, and 4 Hispanics. 2 Caucasian males, 3 Caucasian women, 2 black males, 1 Asian, 1 Hispanic male, and 3 Hispanic women. So that's going to be your pettit jury.
Is
6
that
men, 6
surprising in
women.
any way?
No, not at all. 6 men, 6 women. And all of those, the grandmothers that you talked about, are on that pettit jury. I think we may even have another grandmother, and I say that because the Hispanic woman, she's older than 50, and she has 4 children. So you can think there's a high probability that she's a grandmother as well.
Now, we want to just touch on this real quickly. Why is it important that she's a grandma? I think because that plays sort of in the defense's corner, right?
Absolutely. I believe that this jury is stacked for the defense.
Really?
I really do believe that. Just the makeup of it. Because 3 grandmothers love their grandchildren.
Yeah.
Remember, you have Antonio's grandmother in that audience, in the gallery.
AJ's grandmother.
AJ's grandmother, watching it every day, supporting her grandson. Those grandmothers are going to identify with her. And if she gets on the stand as a grandmother and says, believe my grandbaby, he's telling you the truth, those grandmothers are going to identify with that. No way they don't.
And how many grandmas do we think we have?
I think we have at least 3.
Wow, that's pretty powerful.
That's very
How does
powerful.
the prosecutors work against in that?
It's going to be difficult for them to come across that. I think the way that they'll have to attack it is that, yes, he is a grandson, and yes, he's somebody's son, and this, that, or the other, but what they're going to have to point out is that we all should be held accountable for our wrongdoings, no matter who we are. And that we can't let anyone slide because they're young or they're sympathetic, you know, as a person. That we have to hold people accountable to the law.
I want to do a real quick housekeeping. One thing I want to address is cameras in the courtroom. Do we have an idea how that's going to work? The judge did lay that down a little bit, right?
Yeah, as of now, there will not be cameras inside the courtroom. So what we're doing today with the bench, with this board, will be ideal moving forward through this whole process. We, as the media, are still trying to get Judge Kelly Johnson here we're pleading with her if we can have just 1 camera in the courtroom, at least for opening, closing, and verdict. That's what
I
we're
heard there's a
trying to do.
possibility for closing that she'd allow cameras in the courtroom.
It's
on the fence?
It's iffy. So,
Well, think about why she's doing that.
Why is she doing that?
This case has had so much media attention, right? Remember, the judge on her own, and remember we said sua sponte, that's when a judge does something on their own without pleadings from either side. The judge sua sponte said, we need to move this case to another jurisdiction.
That's right.
Remember?
Yeah.
And it was because of the media attention and how she believed it was tainting the jurors. You can tell a juror whatever you want. Don't do this, don't do that. But when they go home, you can't control what they do. You can't control what they Google. You can't control what news media they look at. So if there are cameras in the courtroom, they're going to hear things that maybe they shouldn't hear.
My question is, are they even going to be going home every night? Is there a chance that they could be sequestered and held up somewhere during this entire trial?
good point. Someone brought that up yesterday, and the judge said for the testimony, she does not believe that they were due sequestered. They don't think they're sequestered, the juror members. But she said there may be a probability during deliberation that the jurors will be sequestered. She said something along the lines like, you can read between the lines there. So for my judgment, I took that as likely the jurors will be sequestered during deliberation. You
I bet they
mentioned
will.
You mentioned the outside influences. Someone was excused yesterday morning because they said their wife is very interested in true crime, so she connected the dots that he was a prospective juror on this case. And so he brought that forward to the judge, and the judge was trying to ask, well, do you think you can be fair? Rick DeToto asked him, well, what's the opinion that your wife has? Does she have guilt or innocence? And he's like, she thinks he's guilty. And he pressed, he was like, well, do you think she will influence you? He says, probably. And so Rick makes that motion. We need this person.
He has to go.
Judge Kelly Johnson has done a really good job, sticking to her schedule. She said this is going to happen now. So how long do we think the actual trial is going to be? When does it start officially?
Monday at 8:30. No, Monday at 8:30 a.m.
8:30 a.m. Monday. And then do we have any idea how long it's going to be?
I think about 3 weeks. So if you look at the history of the last two trials, I think one lasted 22 days. The other one lasted a little over 2 weeks. So I would just say 3 weeks to be safe, because, or maybe a little less. They're going to streamline the evidence a little bit more this time, but they're going to get into things, I think, a little deeper that maybe they saw worked with the jury. Remember, every time that the jurors finish their case and deliberating, the defendant's counsel as well as the prosecution gets to go back and talk to those jurors and ask them, what were you hung up on? You know, asking the ones for guilty, what was your problem? The ones who thought he was not guilty, what was your issue? And they're going to focus on those things.
I want to talk real quickly, if we can, about the things that are going to happen actually starting within a few minutes here, these motions. So I think, as I understand it, Rick DeToto and his defense team, they want to introduce video of a burglary, I think, that happened at Antonio Sr.'s business, his gym. And I mean, is that relevant? Do you think the judge would let that video in? I'm not sure what that shows exactly.
I think it's relevant. The defense has a right to put on whatever defensive theory that they want, okay, as long as the evidence is credible. Of course, if you have a video of someone breaking into a gym, that's pretty credible. And it shows that there is someone out there that could be targeting Antonio. I'm sorry, the father, and so that's something that I believe is very relevant to the defensive theory that someone else did this other than AJ.
And are they going to point specifically at anybody in particular when they get us trying to think in that direction?
They're going to, if they're smart, which Rick DeToto is, otherwise he wouldn't have hung two juries, right? They're going to focus on anyone other than AJ, i.e. the brother, as well as someone who's out there that may have a vendetta against the father.
You mentioned the brother. That's also part of the motion, trying to bring in his medical records in, because that's something they tried to use during the second retrial, trying to point to someone else. Because I'm assuming the jurors will want to know, well, if it's not AJ, then who?
But it didn't work, though, did it? They didn't let those medical records in last time.
So they're going to try again this time.
They're going to try again.
And let's talk about the things that may be different this third time around now. Let's talk about opening statements, which I guess we'll start hearing on Monday after we get through all these motions. And I want to start, if we can, set this up from the last trial. This is from trial number 2, and this is the prosecution's opening statement for trial number 2. If we can give a listen to that, then we'll kind of see, we'll go from there.
On July 28, 2016, Antonio Armstrong Sr. and his wife Dawn went to bed in their Southwest Houston home. When they went to bed that night, the doors and the windows were locked and the alarm system was on. In the Armstrong household were 4 people: Antonio Sr., Dawn, their daughter, 12-year-old Kayra Armstrong, and the defendant, then 16-year-old Antonio Armstrong Jr. When Antonio Sr. and Dawn went to bed that night, you will hear evidence that they were shot in the head. And while this happened, the alarm was on, the doors and the windows were still locked. You're going to hear that Dawn Armstrong was shot twice in the side of her head, and she died instantly. Antonio Armstrong Sr. was shot once in his head, and as he lay there next to his wife, he struggled to breathe. He was unconscious. Paramedics arrived. They rushed him to a hospital to try and save his life, but he died the next day. Before these two were ever complainants in a capital murder indictment, the Armstrongs seemingly had it all. Antonio Armstrong Jr. was an All-American linebacker at Texas A&M. He went on to play professional football for the Miami Dolphins. He married the love of his life, Dawn. You're going to hear that Dawn was a strong woman who cared about her children fiercely. But she also wasn't afraid to put her foot down when she needed to be the disciplinarian between the two. You're going to hear that that night, the doors and the windows were locked, the alarm was on, and those doors were never breached until the police arrived at that scene.
All right, so that is Prosecutor Ryan Trask, who's on the team again, right?
Yeah.
It's basically all of the same players, isn't it?
It is.
My question is, are they going to take that tack, which they really sort of keyed in on, at least in 2022, and I think the first trial, too, back in 19, was that idea that, look, this home was sealed. The burglar alarm was on. The doors and windows weren't breached, although there's a little bit of, depending on your point of view on that. Are they going to take that tack this time?
Oh yeah, they have to. To me, it's just their strongest piece of evidence is that that alarm system was never tripped the entire night. So if it was never tripped, that means no one came in and no one left out. That is their strongest piece of evidence. They're going to focus on that, as they did in this opening statement. They're also going to focus on the argument and the tumultuous relationship that they believe that AJ had with his parents during that time. And so those are the things that they're going to focus on. But the question becomes, and I think what's hard for those jurors who keep voting for not guilty, is that teenagers argue with their parents all the time.
Right.
It doesn't cause them to kill them and execute them. And so that's the hurdle that is hard for them to get over, because just as much as the prosecution is arguing, hey, this alarm system was never tripped, nothing could have come in or out, no one coming in or out, the defense is going to say, yeah, but it's not foolproof.
Yeah. That's right. They say they sort of question the data that the alarm company has presented as, look, there have been mistakes or errors before. They kind of want to chisel away at that, right?
They do.
And that's what has been interesting during this voir dire process, that Rick DeToto has been pressing people who have some kind of background in technology, in science, asking them they get this fill out paperwork where it explains, are you a detailed-oriented person or an open thinker? So when they say detailed, DeToto during this whole pre-trial stuff is asking, what does that mean? So if something goes off, are you going to, if an alarm system doesn't work, how does that work in your mind? Explain that. Because of all this prep we've had going into the bench, when Rick would ask those questions, I understood exactly what he was trying to figure out. So in this jury, we have two people who work in tech, in that kind of field, and they were people who said, well, not tech. Every tech isn't foolproof.
Right.
There are going to be issues. And after that, kind of, those people would say things, Rick was done.
To me, it seems like sort of a big hill to climb, because, I mean, if nobody set off the burglar alarm, nobody set it off, although I know he's shooting holes in that theory. They do have an idea that something happened with the garage door.
That's the whole thing.
What is the deal with
family,
that?
His sister, I believe in the last trial, has testified saying that, well, the garage alarm system was tricky. Sometimes it worked, sometimes it didn't. So that's something I expect DeToto and the defense to really lean on.
Let's take a second to hear now. Let's go to the defense's opening statements back in 2022, and we'll sort of compare and contrast real quickly. Let's give that a listen.
In fact, AJ was on with his girlfriend. Now, based on their speculated timeline,
Objection to argument.
Sustained.
he was on the phone with his girlfriend minutes before this alleged happened. And his girlfriend's gonna tell you, I was talking to AJ. You're gonna see some text messages. He was normal. In fact, his girlfriend's parents overheard the conversation. They love AJ. They think highly of him. He was fine. Nothing out of the ordinary. The evidence is going to show his such that there's no way he just executed his parents.
Objection to argument.
Sustained.
Sit down, Chris. Sorry. The alarm system. What the evidence will show you, and they didn't tell you, is wrong. They wrong about the alarm system. We have a person who is going to testify about the garage door. And when I say the garage door, I mean garage into the house. The evidence is going to show you that there was a keypad on the outside to open the garage door. Many of you probably have one. So you use the keypad, the garage door opens, you walk through the garage, and you open that door to get into the house. They tell you that the evidence is going to show that that house is locked tight. They have to. But this expert is going to tell you that if the door from the garage into the house is cracked.
Okay, so that is Rick DeToto back in 2022, the second AJ Armstrong trial. But Tisha, this is your bailiwick. This is your job. Do you like that opening? Is that effective in sort of sowing the seeds of doubt?
Very effective. And the reason being is he focused on 2 points. One point being the trickiness of the garage door and how it affects the alarm system. And basically what he's done is given the jury an out as to why maybe the alarm system did not go off. And he talked about that there will be an expert that's going to come in and say that if that garage door was open, then it wouldn't set off the alarm because the alarm would not properly function if that is the case. And that's where their sister comes in and says, yes, we always had an issue with the garage door, and that is what normally happens. It doesn't go off. So that kind of dispels the prosecution's whole theory. The second thing that I think that Rick did, what was very effective, was that around that time he was texting his girlfriend, and that the girlfriend says he appeared very normal. And even better than that was the girlfriend's parents who said, I overheard the conversation that they were having, and the kid appeared normal, and we think very highly of this kid. So those 2 factors, and then when you just play the odds of it, the odds that because my parents and I are not getting along, I'm going to execute them. It just doesn't play well.
Make a point there before I head up
you gotta go
inside
soon.
here. The girlfriend, now wife, she was present yesterday holding hands. I think she'll be also in the room with the grandparents throughout this trial. So now I'm going to run up inside for those pre-trial motions.
Rilwan,
See you
good
all.
to see you. Have a good day. We'll check in a little bit. So Letitia, let's continue this as he heads up there, and of course he's going to be our guy who's sort of plugged into all the motions that are going to happen today. My question is, opening statements, is the idea there, and there was an objection right in the prosecution objected right in his opening statement, is the idea just to sort of give you an umbrella view of, hey, here's where the prosecution's got it wrong?
Yes.
That's it.
That's it. It's a roadmap. That's what opening statements are. Opening statements are not meant to be arguments, and that's a lot of times what draws objections in opening statements, is when the lawyer starts to argue the case. You can't argue the case. You can only talk about what you believe the facts will show. Now, your opinion about those facts are reserved for closing arguments. That's why it's called opening statement and closing arguments.
That's a good primer on that. Okay, we're going to listen to one more soundbite, and it's sort of, I think, one of the jurors from back in 2022 kind of dissected how they went about making their decision during trial number 2. Let's give a listen to that.
I don't see them going to sleep not knowing that their home is secure. So to me, the house is secure, so I don't see there's no physical damage, I'm sorry,
You're good.
of intruders, or it just, I mean, the murder is still in the house. It was pretty obvious to me. And then I feel like the note was just a distraction to make you think it was from someone else.
Was there one piece of evidence that they were really hung up on, or was it just kind of a collection of different things?
Yes, they just kept going back to the alarm system and how there was a testimony on how it may have not been fully functioning. So that was their main focus on, like, how can we really rely on the alarm records if there was a testify that it wasn't really functioning fully. So that was their main focus.
I think essentially that juror is saying, I mean, what that shows really is how important, it's whether or not you're on board with the house was actually sealed,
Yeah.
the alarm stayed on and nobody came in. I mean, you're either on board with that idea at the end of the day or you're not on board with
Right. And I think that jurors, they err towards the side of caution.
that. Which side is caution in this?
Beyond a reasonable doubt.
Okay.
That's the caution. You have to remember what a high burden that is. Remember, and I always educate jurors and I empower them and tell them, when you're in family court, the evidence is clear and convincing before someone can take their children
Different
away
standard.
from you. Totally different standard and a lower burden than what you have in that criminal courthouse over there. A clear and convincing evidence is all you need to take your children away from you. That's pretty dramatic when you think about that burden, right?
Surely.
And you think that that's something that you believe should be very concrete before you come and take my child away from me. Well, even higher than that is beyond a reasonable doubt. And so when you think about that high burden, it should cause you pause before you convict someone. Add to that there is an explanation as to why that alarm did not go off. Add to that the normal child does not execute their parents because they're not getting along. It's very difficult for jurors to get across that, and it will be very difficult to get 12 to agree with that.
In fact, prosecution in 2 previous trials, they haven't been able to get around that.
And that's the reason.
Okay. So I wanted to talk a little bit, if we can. So everything's going to get going on Monday. Are they going to be taking field trips? Are they going to scenes? I mean, what do you expect to happen? Or does everything take place in the courtroom?
Well, normally everything takes place in the courtroom.
Okay.
But if you think about the fact that she previously allowed them to go to the scene, I believe she'll do it again this time. There would be no reason for her not to.
We got to keep in mind that the actual crime happened, what, 7 years ago at this point? It was 2016.
Correct. Yes.
We're in 2023. And this is the 3rd trial. So I know I'm jumping the gun, but I just want to understand all the sort of nuts and bolts of this
Sure.
thing. So when it's all said and done, and you've got the 12 jurors that are actually going to be making the decision, the alternates aren't in that room deliberating,
They
correct?
are not. They are not. Alternates are not allowed in the jury deliberation room. No one is allowed in the jury deliberation room. Not the bailiff, not the lawyers, not the judge. No one can communicate with those jurors but the bailiff. Not even the judge. The only time that the judge can communicate with the jurors are if they are all brought out, seated in the jury panel seats, and spoken to in front of the rest of the court, which is the lawyers for the prosecution as well as the lawyers for the defense.
Are the alternates in the box while there's testimony? Are the alternates
yes.
also sitting in the box?
Remember I told you that they will be sitting along right there next to the jurors that are actually on the petit jury. They'll be right there. Because if someone gets sick, they have to be able to say, I heard all the evidence and I was in the position of the jurors who were on the petit jury.
Is it out of the ordinary to have to lean on a secondary juror, like where you lose one of your main jurors during a trial? I mean, do you expect that to happen?
You do not expect it to happen, but it does happen. It certainly has happened to me. And so it can happen, and that's why you have 4 alternate jurors. You think about a 3-week trial, anything can happen in 3 weeks, anything. And you have 12 people from all different walks of life, all different types of professions with children and family obligations. And so you want to make sure that you can cover if one of those jurors, are gone or have to leave for whatever reason.
They're talking in my ear right now. Apparently we've got a shot of, hey, there he is. I can see him on that monitor. Rilwan is heading into court right now. There he is. I see him right there. He's going to have a nice big day ahead of him. So the things they're hashing out today are basically going to be the guidelines of when we start on Monday. But
Yes.
So you kind of set the playing field of what you're allowed to do and not do.
What you're allowed to do and not do. Number one, it streamlines the trial, that you're not stopping in the middle of trial making these arguments. Let's get this out the way. so that once the trial starts, we can hit the ground running. And jurors hate, and judges hate to do this to jurors, where you're constantly stopping, asking them to leave the room, go into the deliberation room so the lawyers can argue about certain pieces of evidence. So what Judge Johnson is doing now is saying, we're going to hash out the majority of this stuff before trial begins.
All right. Boy, there is a lot ahead of us. Everything gets started in earnest Monday. That's when the trial starts. And then today we're going to hear motions from, I think, primarily the defense, but I guess the prosecution as well, try to get everything folded in so we are ready to go on Monday. Zach, we want to send it back to you. We've discussed a lot out here, I would say.
Yeah, all very fascinating. Joel, thank you very much. The bench continues Monday as opening statements are set to begin. We are following breaking news right now. Senator Paul Bench